Good afternoon, this is Sean Golding with Golding & Golding, here to discuss the basics of the Offshore Asset Protection Trust. In general, offshore asset protection trusts are very complicated. It's a complex area because it involves foreign countries that typically are considered, tax havens or jurisdictions where there's no treaty or where it's known that people move their assets to try to keep them out of the reach of the U.S. government. So with offshore asset protection trust, there's three different scenarios or common scenarios. One, a person may have U.S. assets or assets in a foreign country, and they want to move them offshore. For example, you may want to take your crypto, let's say that you have in a wallet out in the United States, and move it into an offshore country, and then create a trust in that country to try to protect it. Two, you may already have assets in that country or a foreign country, and you want to create an offshore trust to protect those assets. Three, you may have U.S. assets that you want to put into an offshore trust. See, one important concept is with the trust, the actual asset itself doesn't have to necessarily be in the offshore country. You can create a trust in which the source of law is in that offshore country. It's titled for that offshore country. There is a trustee in that offshore country, and the trust states if there's any litigation, it's to take place in that offshore country. So the actual asset itself doesn't have to physically be contained in that country. It's super complicated, like I was saying, but I don't want you to think that your particular asset has to be situated physically in the foreign country where you want to create the offshore trust. So few benefits of an offshore trust. It's harder to sue you for the assets. So assuming in a perfect world that you created an offshore trust in a country that allows for the offshore trust, and you did it before there were any creditors coming after you. Two things that make it very difficult is one, oftentimes in order to pursue litigation in one of these offshore countries, that country requires that the person put up a bond, that the creditor puts up a bond, and getting the bond can be difficult. The cost of the bond can be high, and oftentimes it can outweigh the ability to get the asset, the chances of getting the asset, and you may lose the money. The creditor may lose the money, Also, higher level of proof. In the United States, civil money actions outside of fraud are typically preponderance of the evidence, which is considered like just above 50%. A lot of these foreign countries, there's more elements that need to be proven, and the burden is higher on the creditor. Of course, the idea is to entice people with assets to come into that country and create a trust, so they make it difficult for others who are trying to get in there. A few important facts about offshore asset protection trusts. They're not for estate tax or income tax purposes. In other words, creating an offshore asset protection trust is not going to provide you typically, or at least directly, an estate tax or an income tax benefit. You have an offshore trust, it generates income. You're going to have to report that as taxable depending what's grantor, non-grantor, who, are there any distributions, that's a whole nother area. But there's taxes still have to be paid on the income that's being generated, and there's generally no estate tax benefit. You have to make sure that you create the trust before there's a creditor who has the right to go after you. If the creditor has the right to come after that asset, and you think you're just going to create the offshore trust and then move the asset into it, it doesn't really work that way. That it has to be before that happens. So timing is crucial. We've had people come to us, they're in the middle of a lawsuit, they want to move the asset offshore. It doesn't really work that way. If you're in a debtor's exam, things of that nature. When you have a foreign trust, you are still required to report that trust, even if it's an offshore asset protection trust, on any one of the international information reporting forms, such as Form 3520, 3520-A. There could be FBAR and FATCA reporting as well, depending on what assets, accounts, investments are in the trust. If you're out of compliance, there's various amnesty programs available to you. If you're willful, or you just can't certify under penalty of perjury that you're non-willful, the VDP, Voluntary Disclosure Program, would be it. Otherwise, if you're non-willful, there's various other options available. There are the streamlined procedures, there's reasonable cause, and there's the delinquency procedures. We got a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation. if you think it's appropriate to your matter and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.